Hey everybody, welcome to my channel today. You are welcome for the excellent lighting. I am actually filming before 10 o'clock p.m. What an achievement. As you've already figured out from the thumbnail and title of this video, today we are talking about how to read a case in law school. Now you're probably going to be able to figure this out yourself after a couple weeks of law school, and your school might actually include some kind of training on how to do this during your orientation. But if you are looking for something to do and learn and prepare for over the summer, this is a good skill to start rolling around in your brain. Unsurprisingly, the first thing you'll need for this process is a case to practice reading. I would suggest very short cases with pretty simple concepts. Criminal cases could be an interesting thing to do. I happen to still have my contracts textbook, and so that is what I will be using today. I'm also going to link for you the case that I will be reading today so that you can follow along yourself. You can find that link in the description below. So go ahead, pause the video, click that link, and then come back, please. The case we're reading today is called Dougherty v. Salt, and it's one of the very first cases I ever read in law school. Like I said, this is a case about contracts, and specifically something called donative promises. Now, to give you a general idea of what that means, donative promise is simply a promise someone makes out of the goodness of their heart, with nothing being asked for in return. In legal contracts terminology, there's no consideration. Consideration is what you would give somebody in return for them giving you something. So here we're dealing with a simple donative promise, and we're going to see if that is something that can be collected on legally. For this case, it's not particularly necessary because the excerpt that we're reading is so very short, but in general, you might want to have a pen or highlighter on hand so that you can mark the important parts of the case that your professor is likely to ask about the next day in class. For contracts, that's going to be the offer that's made, any consideration that is given, any mention of something called reliance, which we're not going to worry about today, and what the court ultimately holds. However, the most important part of the case is actually none of those things. It's the court's reasoning. The reasoning is very rarely stated in a succinct sentence or two for you to highlight, which often leads to law students highlighting the entire case, which, as you might imagine, is completely pointless. So try to restrain yourself when it comes to highlights. I preferred using underlines anyway. All right, enough chit chat about highlighters. Let's read the case. The plaintiff, a boy of 8 years, received from his aunt, the defendant's testatrix, that just means the person who's in charge of the will, a promissory note for $3,000 payable at her death or before. A promissory note is basically a promise written down on a note. So basically, the defendant, Salt, in this case, promised his nephew, the plaintiff, Dougherty, $3,000, but now has died without ever paying that $3,000. Use was made of a printed form which contains the words value received. In this case, value is referring to the consideration. So he's trying to show that the note would be collectible upon his death had he not paid it prior. By saying the value has been received, the consideration was given, just give the kid his money. Sorry, I just realized I've been talking about the defendant in male pronouns. It's his aunt, so sorry about that. Her name is actually Aunt Tilly, so we'll call her that for now. When she saw Charlie coming in, she said, "Isn't he a nice boy?" Skipping along, "I don't intend to take it out and talk. I would like to take care of him now." Aunt Tilly said, "Why can't I make a note out to him?" Basically, the guardian wrote out a note, Aunt Tilly signed it. She handed the note to her nephew and said, "You have always done for me, and I have signed this note for you. Do not lose it. Someday it will be valuable." So Aunt Tilly is saying, I don't want to just say I'm going to take care of you. I'm actually going to take care of you. If I don't give you $3,000 before I die, you will definitely get $3,000 when I die. Here's proof. I signed the note. It's valuable. She has every intention of making this promise legal and able to be collected upon. Let's see what happens. The New York Court of Appeals says the note was the voluntary and unenforceable promise of an executory gift. This child of 8 was not a creditor, nor dealt with as one. The aunt was not paying a debt, she was conferring a bounty. The promise was neither offered nor accepted with any other purpose. Nothing is consideration that is not regarded as such by both parties. So the court is saying here, just because Dougherty was a nice kid and nice to his aunt doesn't mean that he was being nice in order to get the $3,000. because he didn't consider his kindness to her or general good character as consideration for the promise, it doesn't count as such. Even if the aunt writes on a note, value received, saying that she considers what he did consideration. We hold, therefore, that the verdict of the jury was contrary to law and the trial judge was right in setting it aside. So procedurally what happened was Aunt Tilly died, Dougherty asked for his money, the estate said no, so Dougherty sued for the $3,000, basing that suit upon this note. The jury said, yes, you should get the money. The judge said, that is incorrect, you don't get the money. And Dougherty appealed to the appellate court, which agreed with the trial judge, saying, no, the jury's conclusion was not based in law, and therefore you are not entitled to the $3,000 your aunt promised you. Sorry. So this case ends up being a pretty big bummer, and you'll find that that's the case a lot of the time in law school. I remember this particularly being an issue in contracts. I didn't like how they turned out so much of the time, and this really was like the first case we read. It's the first one in our case book. And like I said, this is a simple subject because I don't want to overcomplicate things when I'm just trying to explain how to read a case. So now that we've read the case, we understand what the theme is about. Let's go back and see what the professor wants you to get out of it. First and most basically, what is the ruling of the appellate court? Can you think of it? The ruling of the appellate court is that Dougherty is not entitled to the money his aunt promised him. Second, what is the reasoning of the appellate court? Again, think it through. The point here is not for me to give you the answers, but to double check your reasoning as you build up this skill. The reasoning is founded upon there being no consideration for Aunt Tilly's promise. Furthermore, just because one party, the promising party in fact, considers something that the would-be receiving party has done as consideration does not make it legally considered to be consideration. If you're in law school, you're writing all of this down when you're reading the case beforehand so that you can be prepared for class the next day. So you would also be writing down the parties, their relationship to one another, the promise being sued upon, which here is $3,000, very important in contracts. And it would probably be helpful the first couple weeks at least to write down any new terms or rules that you come across. So perhaps testatrix and promissory note, estate, consideration, donative promise would be good examples of this kind of vocabulary that you're going to need to be familiar with, especially when you get to more difficult cases. You don't want to be dealing with the easy stuff. I don't know about you, but I found this exercise kind of fun, and I would definitely be down to do this again if you guys would be interested. If you are, let me know by giving this video a thumbs up. Let's say if we get to 30 likes, we will do this kind of video again with a case that I read for one of my other 1L classes. Leave any questions that you have in the comments below, and let me know what you thought about the outcome of Dougherty v. Salt. I will see you guys next Monday with another video, and until then, God bless.